In this lecture today, we will see the powers of the trustees. We have seen the duties, liabilities, and rights. When you say duties, an obligation recognized and effected by the law to conform to a particular standard of conduct towards another. Duties may be defined in another way also. A legal obligation that is owned or due to another and that needs to be satisfied. An obligation for which somebody else has a corresponding rights. We have seen the liabilities. Liability signifies that condition of affairs which gives rise to an obligation to do a particular thing to be enforced by action. We have seen the right also. Right is defined to mean that which a man is entitled to have or to do or to receive from another within the limits prescribed by law. Power means authority to give one to another to act for him or to do something specified acts, to do something or some specified acts. So the power is ability to do it. Now we will see the powers of the trustees. Section 38. A trustee has the power to grant lease of the trust property if it would be for the benefit of beneficiary. No trustee can lease out the trust property exceeding 10 years from the date of lease agreement or to a date later than the date termination of trust. Further, it should reserve best yearly rent. With the permission of the court, the trustee can lease out trust property more than 10 years. This provision is intended for the benefit of beneficiaries by treating the lease. That's why when you read the section, now we will read the section here, except with the permission of the court and subject to the special statutory provision in that behalf. Then there must be without any permission of the court or subject to any special statutory provision in that behalf in relation to the lease out. Other than those two circumstances, no trustee shall lease out the trust property for a term expiring at a date later than the end of 10 years from the date of execution of the lease, if the date of termination of trust is ascertained for a term expiring at a date later than the date of termination, no, without reserving best yearly rent that can be reasonably obtained. Subsection 2. Any lease executed without permission of the court for a term exceeding the limits authorized by this section, that's 10 years, shall be void to the extent to which it exceeds set limits. That's why we have seen here, when you read this section simply, the trustee has the power to grant lease of the trust property if it would be for the benefit of beneficiary. No trustee lease the trust property exceeding 10 years from the date of lease agreement or to a date later than the date termination of trust. Further, it shall reserve best yearly rent. With the permission of the court, trustee can lease the trust property more than 10 years. This provision is intended for the benefit of beneficiary by treating the lease exceeding 10 years as void. Then we will move to other slide here, 39. If a property is leased by a trustee, the presumption is against the permanent lease. Now, when we talk about this lease, we must see where there is more than one trustees. When there are more than one trustees, then all the trustees have to concur in granting of lease. All of them must join in granting the lease by signing the deed of lease. So managing the trustee alone has no power to grant lease of trust property without concurrence of other trustees. If all trustees do not join in the execution of any conveyance of the trust property, the conveyance is invalid. This is because all the trustees form one collective group and must exercise power in joint capacity and separately. Now we will see section 39. Where a trustee is empowered to sell any trust property, he may sell the same subject to prior charges or not, either together or in lots, by public auction or private contract, and either in one time or several times, unless the instrument of trust otherwise directs. Therefore, once again, I would like to emphasize here, if the instrument of trust provides any matters in relation to this one sale of property, then the trustees must concentrate the provisions of the clauses of the instrument of trust. But here, unless the instrument of trust otherwise directs, then we have to follow this one. The trustee is empowered to sell any trust property. He may sell the same subject to prior charges or not, together or in lots, by public auction or the private contract, in one time or several times. Section 39 prescribes the procedure to be followed by the trustees in executing a trust for sale. The trust property may be sold either together or in lots, by public auction and private contract, and either in one time or at several times. Provisions of section 39 is subject to the directions given in the instrument of trust for executing a sale for trust. If the trust deed lays down the special procedure, then that procedure shall prevail. Under the Trusts Ordinance, a trustee has no right to sell the trust property. He can do so if the deed of trust, that is the instrument of trust, confers such a power. If the power of sale is granted, he cannot give the possession of the trust property without receiving the purchase price. The power of sale must be exercised in good faith, and if it is not, the court may control the power. The trustee shall have the duty to obtain best price for the trust property. Where there is a power of sale, trustee cannot exchange the property. If a trust for sale is vested in a trustee or his heirs, such power cannot be assigned to any other person. Even though a trustee for sale is entitled to sell the trust property by public auction or the private contract, a publicity regarding the intended sale shall be given. The requirement of section 15 of the trust ordinance will be applicable. That is a reasonable prudent man theory. If a trustee is required to sell the property as soon as conveniently, he must sell it within the reasonable time period. If he refuses to accept the offers made by parties and later he has to sell the trust property at a lower price or lesser price, the trustee is liable to make good the loss. Where the trustee has taken the advice of the reputed firm of auctioneers, the trustee is not liable. Trustee is required to sell the property under the order of the court. The trustee is to take steps which may be reasonably requisite for the preservation of property and to deal with trust property as carefully as a man of ordinary prudence would deal with such property if it were his own. Section 15, we have already studied this section. Section 15 of the Trusts Ordinance expressly lays down that in the absence of a contract to the contrary, a trustee so dealing is not responsible for loss or destruction or deterioration of trust property. Now we will move to section 40. When you read this section 40 subsection 1, the trustee making any such sale may insert such reasonable stipulations either as to title or evidence of title or terms of payment or otherwise in any condition of sale or contract for sale as he thinks fit, and may also buy in the property or any part thereof at any sale by auction and rescind or vary any contract for sale and resell the property so bought in or as to which the contract is so rescinded without being responsible to the beneficiaries for any loss occasioned thereby, provided he shall have acted in good faith without negligence. He shall have acted in good faith and without negligence. Now we will see subsection 2 here, where a trustee is directed to sell trust property or to invest trust money in the purchase of property, he may exercise a reasonable discretion as to the time of effecting the sale or purchase. In terms of section 40, subsection 1, a trustee has the power to insert material requirements as to the title or terms of payment or otherwise in any condition of sale or agreement for sale. Further, trustee has the power to buy and resell the trust property at any sale by auction and to rescind or vary any agreement for sale. Under section 40, trustee is not responsible to the beneficiary for any loss if he acted in good faith without negligence. Where a trustee is directed to sell the trust property and purchase another, he may have the discretion as to the time of effecting the sale and purchase. If it requires to sell the property at a convenient period or convenient speed, trustee may sell it within the reasonable time. But if any time period is specified, the trustee cannot postpone the sale and purchase indefinite period. The words reasonable discretion in an honest plain language means do as you like. That's the definition given in Re Norrington case. Now we will see other case, Re Crowther case. In Re Crowther case, the testator had devised and bequeathed his estate, which include his estate which includes his business upon a trust for sale. Then in this case, the testator had devised the bequeathed his estate plus another business, that ongoing business for trust for sale. The proceeds of the sale should be invested and held upon trusts for his wife. Trustee had a power to postpone the sale subject to the income being paid to the same person. The trustee carried on business for 22 years, not with a view to sale, but for the benefit of widow. It was held that the absolute discretion given to the trustees to postpone the sale involved power to carry on the business during the period of business. When a settlor as prescribed a condition for exercise of sale of trust property, the trustee has to fulfill such condition before sale. Trustee may impose special conditions for sale which are reasonable. Likewise, such stipulation for cancellation of contract or withdrawal from contract by trustee must be reasonable. If the sale is by auction, the trustee may stipulate a reserve price in bidding. If the amount fixed as reserved price and the reserve price is not reached in bidding, the trustee may himself buy the property at that price. There is a reserve price, the amount is fixed as reserve price, and the reserve price is not reached in bidding, then the trustee may purchase the property or buy the property at that price. Then in the Gaslight and Coke Company Limited, Coke Company and Towers Limited case, the sale of shares of a company may be held subject to the condition that the voting in the forthcoming election of directors should be in a particular way, and such condition is held to be valid. Because condition may be imposed by trustee. The trustees cannot deliver the possession of the property sold unless he has obtained the full price. When they have sold without obtaining sale price and the property has changed the hands of trustees, then the trustees would be liable for the loss to the estate thereby caused. Where they have themselves elected to affirm the sale without receipt of consideration money, the trustees must pay the interest on the unpaid consideration money. When the property is to be sold jointly by the trustees, then a joint sale is necessary. But in such a case, there must be an apportionment of price before the contract is entered into. Their share of the trustees relating to said joint sale must be paid to the trustees. It is held that in such a case, the purchaser shall not get acquittance unless there is an apportionment and payment to the trustees. The sale is by auction. The auctioneers, when the sale is by auction, the auctioneers may be permitted to receive the deposit of purchase money from the successful bidder. But when the sale is private or solicitor is authorized to negotiate the sale, or through auction, the solicitor or the auctioneer, as the case may be, cannot retain the purchase money till it is reasonably necessary to transfer the money to the trustees. However, if the trustees allowed such price to remain with the solicitor or auctioneer for an unreasonably long period, the loss occasioned thereby has to be compensated by the trustees. Now we will move to other section. Section 41. Section 41, for the purpose of completing any such sale, the trustee shall have the power to convey or otherwise dispose of the property sold in such manner as may be necessary. Section 41 empowers the trustees to convey or otherwise dispose of trust property sold for the purpose of completing the sale, and under section complete a sale under section 39 or section 39 or section 40 of the Trusts Ordinance. Section 42, subsection 1, a trustee may, at his discretion, calling any trust property invested in any security and invest the same on any of the securities mentioned or referred to in section 20, and from time to time vary such investment for others of the same nature. Now we will see subsection 2 of section 42. When any movable property is subject matter of any trust, the court may authorize any sale or exchange or mortgage or other disposition of the trust property which it considers to be in the interest of the objects of the trust. Subsection 3, nothing contained in subsection 2 shall be deemed to derogate the rights of the trustees under subsection 1. When you see this section 42, section 42 enables a trustee to vary the investment of trust fund from time to time. However, section 42 of the Trust Ordinance limits such power because the change in the investment is permissible in securities mentioned or referred to in section 20 of the Trust Ordinance. The power of the trustee to vary the investment from time to time is not unrestricted. A trustee is not entitled to go outside the range of investment authorized by the statute or by instrument of trust. Statutory investment as provided in section 20 of the Trust Ordinance can be availed of unless expressly forbidden by the instrument of trust. The trustee is entitled to vary the investment not only to the fund that are already invested, but also to cash with hands of the trustees pending investment. Then when you see the last sentence that we have studied now, the trustee is entitled to vary the investment not only the fund already invested, but also whatever money they have in hand of the trustees. The trustee is empowered to change from an authorized to another authorized investment if the change in investment yield better rates of interest. Always it is for the benefit of beneficiaries. The trustee has no power to vary the investment in order to benefit one beneficiary as against another or others. This is because the trustee under the law has to deal impartially with the beneficiaries when there are more beneficiaries than one. The onus to prove that the change of investment is fit and proper and would benefit the trust and the beneficiaries is upon the trustee if such question arises in court of law. Now we will move to other section, section 43. Section 43 talking about what? That's where any property is held by trustee in trust for the minor, either for life or any greater interest, and whether the absolutely or contingently on his attaining the age of majority or on the occurrence of any event before his attaining that age, the trustee may, at his sole discretion, pay to the minor's parent or guardian, if any, or otherwise, apply for or towards the minor's maintenance, education, or benefit the income of the property or any part thereof, whether there is any other fund applicable to same purpose or any other person bound by law to provide for the minor's maintenance, education or not. And you see in subsection 2, the trustee shall accumulate all the residue of the income in the way of compound interest by investing the same and the resulting income thereof from time to time in securities in which he is by the instrument of trust, if any, or by section 20 of the trust ordinance, authorized to invest the trust money, and shall hold the accumulations for the benefit of minor, but so that the trustee may at any time, if he thinks fit, apply the accumulations or any part thereof as if the same were income arising in the current year. Now we will go to other slide and see the subsection 3 and 4. This section applies only if and as far as contrary intention is not expressed in the instrument of trust, and shall have effect subject to terms of the instrument and to the provisions therein contained. Where the income of the trust property is insufficient, that's very important. Where the income of the trust property is insufficient for the minor's maintenance, education, marriage, advancement in life, the trustee may, with the permission of the court, not otherwise, apply the whole or any part of such property, not the income of the property, the part of such property for or towards such maintenance, education, marriage and advancement. Now when you see this section 43, the section 43 provides for the expenditure out of the income as well as capital under certain circumstances when the property is held by a trustee for the benefit of minor. This power to expend would apply when the minor has vested interest in the trust property. When the trustee has been under deed of trust obliged to maintain education and bringing up children, but brings them up in an immoral manner, he commits a breach of trust. When there are other funds for the meeting of such expenses, then the court would not permit the trustees to exercise the discretion for the purposes of section 43. It may be said that it is for the promotion and protection of child rights. When the father of minor is alive and is unable to maintain a minor son, no question of maintaining with the income of the trust would arise, because it is for the benefit of beneficiary. But the question would be otherwise if the father himself, indigent, and has borrowed for the maintaining the minor, then the trustee can provide for expenses for maintenance, education, etc. of minor from the income of the trust created for the benefit of minors. When there is a legacy in favor of a minor, the executor of a will may pay out of the interest to the guardian to maintain the minor when the guardian is unable to maintain the minor. If the interest is sufficient to meet maintenance of 1 year, there can be adjustment from income of succeeding year. Section 43. This power under section 43 may be excluded by the settlor or testator by making a provision in a specified manner. However, when there is no such express provision in the trustee is entitled to use the discretion to pay the money for the maintenance, education, etc. of minor on being satisfied about such necessity. Section 43 gives a discretion to the trustee in respect of maintenance, education, etc. of minor when the trustee is for minors. But if the trustee exercises his discretion bona fide, the court will not interfere with such discretion. Then always the trustees must act bona fide and exercise their jurisdiction bona fide, then the court will not interfere with such discretion. But the discretion is not arbitrary but subject to control of the court. If the trustee made payment to the guardian of minor without using the discretion bona fide, the court may call upon the guardian to account for the money so received. However, trustee in his discretion cannot pay the expenses for future but also the expenses already incurred by the guardian for the maintenance or education of the minors. Therefore, what we have studied now, the trustee cannot pay the expenses for future or already incurred by any parent or guardian. When the income of the trust property is insufficient to meet the expenses for maintenance and education, etc., or other purpose mentioned in section 43, then it would be open to the trustee to meet the expenses out of the capital. That's a power is given by section 43 of the trust ordinance to the trustees. Now we will move to section 44. Section 44 of the trust ordinance authorizes the trustees to give a receipt in writing for any monies, securities, or other movable property payable, transferable, and deliverable to him by reason or in the exercise of any trust. If there are more than one trustees, the receipt has to be given by all of them. However, if the trust is incorporated under section 114 of the Trusts Ordinance, it may be signed by authorized trustee by the Board of Trustees, because if it is incorporated, the trust is a legal person. Such receipts would be good discharge to the person paying the same in the absence of any fraud. Again, we must see the power to give the receipt, how to be exercised. When there are more trustees than one, all the trustees must join in the receipt unless the instrument of trust authorizes one of the several trustees to give a discharge. In the absence of such receipt clause in the instrument of trust, specially worded authorizing one of the trustees to grant a valid receipt on that behalf of the trust, a receipt of money has to be authenticated by the whole body of trustees and not merely by majority. Even when some out of the several trustees are selling the trust property, they cannot insist on payment of the purchase money into their hands without all of them joining in the receipt. As regards the rule of granting the receipts by all of them, a distinction has been made relating to the receipt of income such as rents and out of corpus dividends. The trustee may delegate to one of them to grant receipt of the rent received, which is a rule of convenience because it would not be possible for all of them to be present to receive rent always. Now we will move to section 45. Section 45, subsection 1, two or more trustees acting together, or if there is only one trustee of the trust, such trustee may, if and as they or he shall think fit, accept any composition or any security for debts or for any property claimed, and allow any time for a payment of any debt, compromise, compound, abandon, submit to arbitration, or otherwise settle any debt, account, claim, things, whatever relating to trust. And finally, D paragraph also there. For any of those purposes, enter into, give, execute, and do such agreements, instrument of composition or arrangement, releases, and other things as to them or him seem expedient, without being responsible for any loss occasioned by any act or thing so done by them or him in good faith and without negligence. When we see subsection 2 of section 45, the powers conferred by subsection 1 on 2 or more trustees acting together may be exercised by sole acting trustee when by the instrument of trust, if any, a sole trustee is authorized to execute the trust and powers thereof. Now we will see other sections also here. Subsection 3. This section applies only if and as far as a contrary intention is not expressed in the instrument of trust, if any, and shall have effect subject to the terms of that instrument and to the provisions therein contained. In this case, Earl of Stafford case, it was argued that this section conferred only administrative powers on a trustee, and consequently a trustee could not, in the exercise of his discretion, accept as a part of consideration for a compromise a surrender of an interest under the trust of which he was a trustee without consent of all other beneficiaries. In support of this, it was said that the property recovered as a result of prosecution or the compromise of a claim must be brought into the trust account as an asset of the trust, which could not have been done in relation to a surrendered beneficial interest, where the surrender formed part of the consideration for the compromise of a claim. It is also urged that all the trustees had an undoubted power to compound claims against other parties where this was for the benefit of trust. They had no power, either under general law of equity or by statute, to abandon any part of a claim to the properties as an asset of their trust in consideration of a beneficiary giving up a beneficial interest under a trust, and that the word expedient meant expedient for the trust as a whole. Rejecting this contention, the court held that the expression expedient for the trust as whole must mean the same as expedient in the interest of all the beneficiaries under the trust, provided that it be kept in mind that in considering the interest of the beneficiaries collectively, trustees must take into account that the effect of what was proposed on the several individual interests of the beneficiaries and hold the scale fairly between them. And also we have seen that compounding the debts, the trustee are competent to release or compound a debt if it is beneficial to the trust. When it would not be beneficial to the trustee would be liable for the loss occasioned thereby. Thus, when the beneficiary released a security by way of recognizance without any consideration, he was held liable for the amount of recognitions. A compromise of claim by a trustee or executor of any debt or claim due from the co-trustees or co-executor has to be strictly scrutinized to ascertain if it is bona fide or not. Now we will move to section 46. When an authority to deal with the trust property is given to several trustees and one of them disclaims or dies, the authority may be exercised by continuing trustees unless from the term of the instrument of trust it is apparent that the authority is to be exercised by a number in excess of the number of the remaining trustees. Section 46 deals with the effect of one or more of the trustees appointed under instrument of trust either disclaiming or dying after acceptance. In such circumstances, section 46 of the trust ordinance enables the remaining trustees who have accepted the duty of the trust to exercise all the powers in spite of death or disclaimer of one or more trustees. However, the provisions is subject to contrary conditions in the instrument of trust, which specifically provides for the exercise of powers by the trustees of the number in excess of the number of remaining trustees. When the trustees have to enter into a contract of sale of the trust property with the vendee, then the same can be entered into by the trustees who have accepted the appointment, even though some of them who were appointed have disclaimed. This power of sale can be exercised by the trustees who have accepted the trust, even if others have disclaimed. Likewise, when a contract of sale have been entered into by all of the trustees, and before the sale takes place, one of them dies, the surviving trustees can complete such sale and pass good title. In order to negative the general rule embodied in section 46, there must be express directions in the instrument of trust. When a management of a temple was vested under the trust of 5 trustees, but one of them resigned, a suit was maintainable by surviving trustees, and where one of the surviving trustees also died, pending the appeal, without bringing the legal representatives of the deceased trustee on record, appeal may be continued by the surviving trustees. If the person, now what we are seeing here, if a trustee dies, then the case is maintainable continuously. If there is an appeal, if one trustee dies, again, without bringing the legal representative of the deceased trustee on record, the appeal may be continued by surviving trustees. When a power is given to a trustee is personal, then the power cannot be exercised by trustees other than the original nominee. Now this is an exceptional circumstances. When a power is given to the trustee is personal. then the power cannot be exercised by trustees other than the original trustee nominated. So when the trustee merely personal, when the power is merely personal, the survivors cannot exercise such power because it is a personal and it should be exercised by that person. This is because the power purely personal do not devolve on survivors. It is a pure matter of construction as to whether a power is personal or not. It is depending on the facts of the case, and also it depends on the clauses of the deed of trust. Now we will see section 47. Where a decree has been made in a suit for the execution of trust, the trustee must not exercise any of his powers except conformity with such decree or with the sanction of the court by which the decree has been made, or where the appeal against the decree is pending of the Court of Appeal. But the situation now it will be little bit different, because originally we must go to the district court, then the appeal from the district court decision, it should go to the provincial high court, then finally it should go to the Supreme Court. But anyway, this was the ordinance, was never amended. It is provided that the Court of Appeal, that it should go to the Court of Appeal, but nowadays it should go to the Provincial High Court. Then from the Provincial High Court, the aggrieved party should make the appeal to the Supreme Court. Now in this section, section 47 provides that with the passing of a decree in a suit for the execution of trust, has the effect of suspending the powers of the trustees, which could exercise in terms of the instrument of trust and under the provisions of trusts ordinance. They cannot exercise any of the powers except in conformity with such decree or with the sanction of the court which passed the decree, or where the appeal against the decree is pending of the appellate court, that may be the provincial high court or may be the Supreme Court. Therefore, after passing of such a decree, the executor appointed as a trustee under the will cannot, for instance, pay debts after passing such decree of administration. Trustee cannot also exercise the powers of sale without sanction of the court after passing decree. The powers of investment of the funds are also suspended, and if the trustee desires to exercise such powers, the sanction of the court will be necessary for the investment or change of investment, because all should come under the cover of the court. Therefore, the trustee cannot exercise any other power or deal with the trust assets in any way after passing of such decree, even in due course of administration. If the trustee has to institute a suit or proceeding for and on behalf of a trust, or defend any such proceeding against the trust, he has to seek a sanction of the court. Where the instrument of trust confers the powers of appointment, where the instrument of trust, that's the deed of trust, confers a power of appointment on surviving or continuing trustee after death of trustees to appoint new trustee to fill up the vacancy, such power can be exercised where the suit has been filed only after approval of the choice by court. Even his statutory powers of appointment by trustees must be subject to the control of the courts. Now we have seen powers of the trustees. Now in all these lectures, series of lectures, we have seen liabilities of the trustees, rights of the trustees, duties of the trustees, and finally powers of the trustees. We will stop with this one. Thank you very much.